Hello, this is Anthony Verna of the Law Offices of Anthony Verna, obviously. Welcome to the home office. As you can see, there's my desktop in the background. There's my signed picture of basketball coach Larry Brown back there. And this is my Flyers jersey, because the Flyers just pulled off a historic comeback, beating the Boston Bruins in the series. Sorry, guys. I want to talk about people who file trademarks by themselves, and there's nothing wrong with that. I understand that everybody wants to do things by themselves, but when you receive a trademark office action, and basically that's a rejection to your application, and sometimes they're very technical in nature, sometimes they're very simple, but the Patent and Trademark Office will actually give you this notice in every office action should you file for yourself. Pro se applicant may wish to seek trademark counsel. So they're already throwing some Latin at you by calling you a pro se applicant. I mean, it's correct. Pro se means you are doing it yourself. But they're throwing some Latin at you to begin with, some legal Latin to begin with. Whether or not it's grammatically correct is up to the Latin scholars. But applicant may wish to hire an attorney to assist in prosecuting this application because of the legal technicalities involved. That's what they tell you. They tell you right off the bat, it's technical, and it is highly technical. There are very technical issues involved. Whether it's, I understand a lot of it is business issues, and of course that's where the attorney comes as the mouthpiece for the applicant. But a lot of times we're talking about linguistic issues. A lot of times we're talking about, the trademark law. We're talking about how to get your application through. How narrow is your application going to be? How wide is your goods and descriptions going to be? Those are some of the big issues there. And the reason that the Patent and Trademark Office tells you to find an attorney is because you just don't know if maybe sometimes you're going to come up across a problem that's very complex. For example, I had a client, once pick up the phone and call me and say, look, I filed by myself, and now I have a problem where there's a mark that's the same that was cited against me. What do I do? So when it's the same mark and the goods and services were exactly the same, there might be ways to push that application through. For example, maybe the cited application really is not in use anymore, so it's dead. Who knows? I don't know that by speaking off a hypothetical. But I'm just saying there are ideas that I may have as a trademark attorney that maybe you do not. Maybe it's an application that's related to what you have, and maybe the filings just never happened. So of course you would need some kind of privy between the applicant now and what had happened in the past. My point is that there are very technical issues involved quite often, and for a lot of people whose trademark applications become mired in a trademark opposition proceeding, which is something I can talk about later, because I'm not going to bore you to death with that one today. I'm in a happy mood. It's very highly technical, and of course an opposition proceeding is just that, a proceeding with a legal judgment. And a lot of these issues are very difficult to do if you haven't done 3 of these a day since you came out of law school. So I do suggest that if you're going to be filing a trademark, you do speak to a trademark or attorney who focuses on trademark law, because there are some very highly technical issues involved, and the Patent and Trademark Office will even tell you that themselves. Again, my name is Anthony Verna. You can reach me at 917-348-0108. You can visit my website at nyctrademarks.com. And yes, I know, I'm wearing a Philadelphia Flyers jersey. You never give up your teams. You never give up your teams, even if New York City is 1 mile that way. Talk to you later. Bye.